morning, Counsel.
Good morning, Mr. Chief Justice. Good morning, Your Honors. I'd like to begin by pointing out or noting that the parties do not dispute that a provocation instruction would have been warranted by the evidence. So unless Your Honors have questions with regard to that, I would like to move right on into...
Well, I have a question not as to that, but related to that.
Yes, sir.
The judge didn't say no with regard to the provocation instruction, correct? The judge didn't say, I won't give it.
No, not at all.
The judge said, I'll give it.
Absolutely,
And
Your Honor.
defense counsel said, I don't want it.
Correct.
So what's the judge supposed to do? Supposed to say, I know you, the defense counsel, don't want it because for reasons of strategy you think it will deflect from the main thrust of your defense, but I, in order to make sure this conviction is affirmed, will insist that it be given. That's what you're saying the judge should have done.
Oh, no, not at all. No, that's not at all.
Now, what should the judge have done?
The judge didn't. The judge did exactly right.
The judge should have done something which would require.
No, Your Honor, no. The argument today is what the trial defense counsel should have done, which is to request it.
So you're saying a judge then has to take a course of action which will later result in its reversal of a conviction on appeal?
Well, not at all, Your Honor. No, the argument today is what is trial counsel's deficiency in failing.
Well, I understand, but there are many times, as a former trial judge, there are many times we worry about whether counsel is ineffective, and the judge in charge of the trial protects against that possibility. But you're saying here that there's nothing the judge could have done to save a conviction here.
I don't believe that a trial judge would go against a trial defense counsel's strategy of foregoing the provocation instruction. I'm not. In my own experience, I'd be astonished.
In Woodward, we said the judge should have. With regard to that case, the judge, that instruction should have been given as to voluntary manslaughter, even though the defense counsel didn't want it.
I don't think so.
Well, if how can you have no error on the part of a judge, but error on the part of the defense lawyer for exactly the same situation?
Well, this case it leads me to the heart of the argument, which is this case materially is indistinguishable from the Azevedo case.
What is the evidence here of provocation?
The evidence of provocation here is at the moment that the incident took place, Mr. Glover was frightened. He was scared.
Self-defense, self-defense.
Frightened and scared.
Yeah.
He lashed out without even looking where he was striking, and had no intention of killing a man. That's no different.
But if the judge did not make an error in this case, what I'm getting from that is that the judge is correct in essentially ascertaining that defense counsel's request was not manifestly unreasonable at the time.
No, I don't think that the judge would want to or even be required to override counsel's strategic choice. It's counsel's responsibility to ask for the instruction based on the evidence, and it's exactly the same.
Is it? I mean, it seems to me, and it's pretty traditional law, that if the defense gives the jury two alternatives, the jury is much less likely to believe them because they'll go back and laugh and say the defendant says, that he didn't do it, but if he did it, it was self-defense or something like that. Or how can he say both things? So you want to give the jury one solid alternative. And you had pretty good facts for self-defense here. The guy was scared. He didn't start the altercation. These people came after him. And why wasn't the attorney perfectly manifestly reasonable in saying, I'm going to put all my eggs in one basket? It's a sensible basket. It's the basket that the evidence supports.
The reason it wasn't is because there are some, based on the evidence, the jury could have found, and some of the evidence comes from Mr. Glover's own testimony on cross-examination. There was some testimony and evidence which would tend to defeat self-defense, but would have really no application to provocation.
But you go back to your question about it's just the same as Acevedo. But in Acevedo, I mean, you didn't have the lawyer making explicitly a thing saying, I know I could do both, but I am choosing. I have a strategic reason for choosing one. That wasn't true in Acevedo.
What is true in Azevedo is this court's conclusion that this court concludes that even if it were a tactical decision, it was manifestly unreasonable. So even if the counsel in Azevedo...
Why was it, given the fact that it's better to give them one solid alternative than to give them two and say, well, maybe it was this and maybe it was that?
I disagree, Your Honor, strongly, because it's better to give them two solid alternatives, not just one, but two. Two alternatives that I don't want to say they're complementary, but they're in no sense, in the facts of this case, antagonistic.
Well,
and
in one sense they are, in that for voluntary manslaughter with reasonable provocation, or maybe both of them, but certainly for that, the idea is that there's an intent to kill, but it's excused by something else. You're saying no intention of killing here, correct?
Correct.
How can you get involuntary manslaughter on
Well,
that?
because all forms of manslaughter involve an intentional injury.
No, but voluntary manslaughter involves an intent to kill.
Not if it's reasonable provocation.
Well, that excuses it. But I think you start with the idea that there may be an intentional killing, but it is excused by the heat of passion, correct?
But there's an alternative to the self-defense. And by the way, the motion judge and the appeals court majority, what I consider to be a impressionistic, arbitrary conclusion, they say that this is a very, very strong case for self-defense, and the evidence of provocation is much weaker. And I simply disagree with that assessment. They may not be roughly equivalent, and even for the sake of argument...
This is the problem, of course. Good lawyers will disagree about strategic decisions. A lawyer who was there, watched the trial, watched the witnesses, watched the jury,
right,
had a good sense to assess what might be credible and what might not be so credible. We give deference to those lawyers. And that's what this lawyer did.
And to that, I might add that the judge, who saw all of those things, Your Honor, was very, very reluctant, to the point of almost refusing a self-defense instruction, said no such thing about reasonable provocation. So the argument that these two, that this is primarily a self-defense case and that provocation is an add-on that's going to deflect or cause it to be a less chances for either an outright acquittal or...
So let's say that the lawyer said, okay, give that instruction. But I'm not arguing it. I'm arguing self-defense. Also ineffective assistance of counsel, abandonment of a potential defense, if he doesn't argue it as well.
That probably would be a culpable argument to make. But defense counsel did. It's kind of an academic fact that I'm pointing out, but defense counsel did say that his client was scared at the moment it happened, which I think is the important point. To say that self-defense is the stronger defense, both the motion judge and the appeals court majority, they look to evidence that occurred after the fact when Mr. Glover has gone back to the apartment and he makes these statements that the judges that have ruled against us.
But the lawyer, the important thing is what the lawyer had in front of him in real time.
The lawyer
he knew all of the evidence.
He
had heard it.
Yes.
He had assessed it. He made a judgment that self-defense was the best defense, and he didn't want the jury to be distracted by anything else. Why won't we respect that judgment?
Because there's another alternative to it, and based on the facts, and based on Azevedo, factually the scenario, it runs the same way here as in Azevedo.
That the standard for ineffectiveness is nothing to lose. If there's nothing to lose, counsel is ineffective for not pursuing it.
That may not be true in each and every case, but that's exactly what happened here, Your Honor.
But even so, there might be something to lose here. I mean, some people think that if you give the jury two alternatives, it makes it less likely that they'll focus on the one. So, didn't the attorney here think and make a decision? And how can we say after the fact that it wasn't a tactical, strategic decision that he or she is entitled to make?
Well, it was a tactical and a strategic decision,
Right.
but it was an incorrect one, Your Honor. And again, Azevedo teaches us that. The factual scenario here is the same as it was in Azevedo, with the possible exception of the jury question, which I'll hopefully get to and talk about, then argue that point. But this case is the same as Azevedo.
Okay, but if you're right, it seems to lead to a catch-22 circumstance, that if I'm a defense counsel and I've got two lines of defense. My most sensible course, if you're right and if we agree with you, to say, I'm going to argue the first line of defense. That's my best line of defense. And I'm going to tell the judge I don't wish you to instruct us the second line of defense. This way, if I may prevail and get a not guilty, but if I do get a guilty, the case will be thrown out because I was ineffective for not arguing the second line of defense. So that would seem to be a brilliant strategy for an attorney to maintain, if you're right.
I don't know that, for one thing, Your Honor, I don't know that trial defense counsels would engage in, actively engage in that kind of analysis. in the
Maybe it
heat
would
of-
be ineffective not to,
Well,
if
he
that's
might-
what we were to suggest.
He might be, but in this case, he had everything to gain by presenting two ways to avoid a malice finding, and it's just flat out unreasonable to give up on one. I think the motion.
So you're saying that the defense attorney in another situation should say, my client didn't do it. He wasn't there and he didn't do it. But if he did it, it was self-defense. You're saying, because the evidence would
Well,
support
that's
both.
not. No, Your Honor, I wouldn't go so far as to say that. That's not this case.
No, but what if, I'm asking you about that hypothetical. Evidence supports both things, that whoever did it may have acted in self-defense, but this guy has an alibi and says he wasn't there. So the defendant's counsel should stand up and argue, my guy didn't do it, it was misidentification, he wasn't there, he was with his girlfriend, she testified to that. But if he did it, it was self-defense.
Well, there are cases, and let me try to answer it the best I can this way. There are cases where it would be inconsistent to present to. So then now you're talking about maybe making a reasonable tactical decision
And you're saying it's not inconsistent here, and that's what Acevedo suggested in similar circumstances. So
this
that's your-
case, Your Honor, I can't say it enough, or maybe I don't want to keep saying it over and over again, but in all material respects, with the possible exception of the jury question, which I don't think is a problem, this case is just like Acevedo.
All right, well, let
Just
me
like
ask you,
Acevedo.
well, let me ask you this question then, because I'm trying to figure out all of the standards. We first of all have to decide whether it's ineffective.
Correct.
And that means we have to decide whether the performance of counsel was seriously deficient, then whether there's been some prejudice, because there's got to be both. You're saying the prejudice is, well, the defense wasn't argued, and so that's prejudicial. But don't we have to decide something else here, a third thing? I mean, this is a waived argument. It wasn't raised in a timely fashion.
Correct.
This is the second, is it the second or the third? It's the second motion for a new trial.
Second, yes,
Wasn't
first
raised
one's
in the
night.
first.
Correct.
Wasn't in-
It's waived. It's a waived issue, no
So
question.
we have to look at substantial risk. And substantial risk, isn't that something a little different than ineffective assistance of counsel?
I believe that is true. But on this,
And in Acevedo, the court at the end said, and there was ineffectiveness, manifestly unreasonable,
Yeah.
and there was a substantial risk,
Right.
really looking at the juror's question on the issue of
Well-
substantial risk. We don't have that here.
Well, first thing is that this court, and I think in the Randolph case, this court makes it very clear that, at least at the appellate level, that these ineffective assistance and substantial risk are going to be, they're roughly equivalent. I think arguments can be made at the appropriate time that they are different. Tactically, appellate lawyers may want to bring something on ineffective
So
rather than
you're
substantial
saying
risk.
that the substantial
However,
risk standard is the same as the ineffective assistance of counsel
well,
standard?
I think it is in this particular case, Your Honor. But to get to the jury question, as I read Acevedo, this court says on page, I believe it's page 447 of the Acevedo decision, this court says that even if it was a tactical decision to omit the provocation instruction, trial defense counsel was manifestly unreasonable for making that choice. It's 3 pages later that this court dealt with the jury question.
I know, but that at the end of the opinion, it talks about the jury's second question strongly suggests their willingness to consider other mitigating factors.
Right.
Accordingly, we conclude counsel's failure to request an instruction was manifestly unreasonable. It deprived him of an available defense and created a substantial risk of a miscarriage of justice, because that also was a question of substantial risk of a miscarriage of justice.
I think my response to that is this, that the jury question in Acevedo, of course it plays into the conclusion, and reasonable people may argue about or disagree on how important it is, But that jury question is not necessary, in my view, to this court's finding in Azevedo.
It certainly created a serious doubt whether the result of the trial would have been different, and that's the measure of a substantial risk.
And the jury question in Azevedo is, but, for want of a better term, the frosting on the cake, in my view. And not only that, we have a jury question in this case which may not be, it's not explicit, it's not specific like the jury question in Azevedo, but at least it can be interpreted as some indication on the part of the jury that there is a struggle going on in the jury room with regard to malice and manslaughter.
Your time is up.
Thank you.
All right? Thank you, Your Honors.
Good morning, may it please the court. David O'Sullivan for the Commonwealth. This court in Acevedo did not broadly state clearly that in every case in which the evidence supports both theories of voluntary manslaughter, that is heat of passion and excessive force in self-defense, that counsel must, on pain of reversal, seek both instructions. It reversed counsel's decision in that case not to seek a provocation instruction, but in a very particular factual circumstance that simply isn't present here. The first thing is essentially their counsel was asleep at the wheel. There was no tactical figuring going on by counsel. In fact, in the affidavit submitted in support of his motion for new trial in that case, counsel said, I cannot recall any tactical reason for me to have foregone this instruction. And in fact, even now, I can't think of one, I can't conceive of one as to why this would not have been a good idea.
But why does that matter? I mean, if it's manifestly unreasonable, is it different that the attorney did not think of the defense as opposed to the attorney thought about the defense and made a manifestly unreasonable decision not to ask for it?
Well, we certainly don't argue that it's because it was tactical in nature, it was therefore reasonable. We can't do that. Of course, the court reviews these types of decisions to determine if they're manifestly unreasonable when they're made. But this one was reasonable when it was made. In fact, if you look at the charge conference, you have counsel. It's evident that counsel is thinking deeply about his case based on the evidence that he's seen, and he's exercising his best judgment as to how to secure an acquittal for his client or a reduced verdict. In Acevedo, what you had was the defendant admitting, the defendant testified in that case, and in fact admitted, I could have retreated before the fatal blow, which of course takes him out of the box of self-defense. Here, there's no such admission from the defendant on cross-examination that I could have walked away. So
Is there any, I mean, one of the points that is made, I guess by the defendant anyway, is that it wasn't very far from the apartment. Did that come up at trial?
yes, he did state on cross-examination that there was nothing that separated me from Darlene Flanory's apartment when the fatal confrontation happens.
So isn't that just a matter of a difference in degree between that and Acevedo?
No, well, no, for the following reason. In this case, defense counsel could reasonably think that available avenues of retreat are not any determinative obstacle to me having an acquittal based on self-defense or a reduction of a verdict, because in the defendant's account of the fatal fight, in fact, everyone's account, it turned physically violent in a very quick manner. Even in the defendant's account, most favorable to him, he has the victim beating on his chest saying, my name is Wimpy, I run Lynn. And then at the same time, all of a sudden, he's reaching into his jacket and advancing on the defendant. And in the defendant's version, he swings while he's retreating. So counsel clearly didn't see it as any real obstacle. He faced difficult evidence in the case, but unlike in Acevedo, where there's an express admission from the defendant that I could have retreated, that's different from what we had here. The other thing was that in that case, the facts were more amenable to a heat of passion argument. There, you had the defendant being struck, actually struck about the head at the time where he lashed out, and there were several strikes that the defendant attempted.
Wasn't he on the ground?
He was on the ground, yeah.
I mean, why isn't that so, it seems pretty strong on self-defense to me.
For Acevedo.
Acevedo.
Yeah, and it clearly supported both. But here, in that case, you had him striking out multiple times. Here you have a far more controlled strike, and you have the defendant is not struck before.
But here, you did have the jury acquitting as to the armed robbery, which means they didn't
correct.
credit beyond a reasonable doubt that theory of the prosecution.
That's correct. But that was an event earlier in time that they clearly didn't find occurred.
But which does suggest some skepticism as to the version of events presented by the prosecution witnesses.
Right, but not as to, I would submit, not as to the event, to the account of the fight. Clearly they found malice in the defendants striking out at the victim. And here, unlike in Acevedo, you have the defendant acting in a very, from the defense counsel's perspective at the time, he sees his client moving in a fairly controlled manner. He looks up and down the street before he strikes him. He strikes him when his head is turned away. He jumps back to avoid getting blood on him. And he walks away after the attack in a fairly controlled manner.
So why is that self-defense?
That is self-defense, Your Honor. So that's why, it's from counsel's perspective, he's seeing this as a reasonable path to acquittal, as opposed to the heat of passion and provocation. And you have the defendant's statements from counsel's perspective reflecting a classic self-defense as opposed to heat of passion mentality. He says expressly, better him than me. I figured that I would get him before he got me. I saw him reaching. And he conveyed to Darlene Flannery that he was defending himself.
Who called Darlene Flannery, the defendant of the Commonwealth?
The Commonwealth, Your Honor. And primarily for the purpose of admitting the defendant's post-attack statements, in which he described himself as acting in self-defense and didn't make statements like, I lost my head, anything like that. That would have been more consistent with heat of passion. Now, the main question here is not whether the evidence supported both. Clearly, they did. But was it reasonable for counsel to put all his eggs in the more reasonable basket or to sort of hedge his bets? And I think...
Actually, was it manifestly unreasonable for him to put all of his eggs in one basket? Not was it reasonable, manifestly unreasonable.
Correct. Thank you. And it was not, because for many of the reasons suggested by Justice Cowan, there is an advantage in telling the jury one story, and you, not least of which is that you avoid the possible negative inference from arguing to the jury that either my client is entitled to acquittal or reduction of his verdict because he had this mental state or because he had this mental state. And
but the interesting thing here, though, is that the mental states are overlapping. It's not like you're choosing between insanity and self-defense. You're choosing between self-defense and, I may not have the right to defend myself, but there's combat, and it's sudden combat, and I've lost control. They're not. They're related in ways that many of the other defenses are not.
That's correct. They are related, and they often overlap, as this court said in Acevedo and has said previously. But they're different. Obviously, under the self-defense scenario where the defendant has used a dangerous weapon, he would have to reasonably and actually believe that there was an immediate danger of death or grave bodily injury. And this court has described a defendant acting in response to that based on a cold calculus of survival. In the heat of passion scenario, you have a defendant acting, there's some provocation that would cause an ordinary, reasonable person such a state of anger, fear, fright, or nervous excitement that as would eclipse his capacity to reason. So you have the uncontrolled, unreasonable, inflamed by emotion defendant on one side, and you have the cold calculus of survival on the other. Both are paths to acquittal. The defendant chose the more reasonable path in this case because the evidence was more consistent with it, and he saw it as detracting from his main defense and to even have the jury instruct on the other one, which was perfectly reasonable.
Right, but that calculus of survival need not be a cold calculus. It could be, I mean, if it's self-defense, you fear you're going to die. Mm-hmm. That may generate some degree of emotion in the part of the person making that calculus.
Certainly, and fright and fear are emotions that are invariably felt in the self-defense context, but one is still acting rationally.
Can I ask you a question about, and maybe I'm just not quite thinking right about this, but is substantial risk of a miscarriage of justice, is that the same as ineffective assistance of counsel?
Well, this court has said that they're both sides of the same coin and that they look to whether there's an error and whether the error made a difference in the outcome of the trial. But what's important here and what sort of the standard that the court has to apply, the Kilburn and the Randolph cases make this clear, I'd say, is that there's no substantial risk of a miscarriage of justice as to any waived claim where counsel has made a reasonable tactical choice. So the question here is whether counsel's decision evaluated when he made it was manifestly unreasonable, which is quite a difficult standard for the defendant to meet in this case.
If we find the defendant is ineffective, in other words, defense counsel was ineffective, in other words, was operating substantially below what we would expect of a normal attorney, and that it might have made a difference, or that it deprived the defendant of a substantial ground of defense, then that's enough. That establishes substantial risk of a miscarriage of justice.
The Commonwealth's position is that is not enough. He has to show that it was manifestly unreasonable.
Well, that's part of the
No, but
deficiency piece.
that goes to whether it's ineffective or not.
Yeah, it was whether until it was deficient performance.
Oh,
I mean,
right.
a strategic decision is not deficient unless it's manifestly unreasonable.
Yeah, I'm sorry.
All right.
That's correct.
Okay.
Now, do you share Mr. Keegley's view that even where a decision by defense counsel is manifestly unreasonable not to seek a defense, that the judge should still concur with it?
The judge has to give deference to those reasonable tactical choices that the defendant makes. In this case, counsel would have, or the defendant would have the judge micromanaging the defense, essentially.
But I mean, I know that you're claiming it's not manifestly unreasonable, and certainly where it's not manifestly unreasonable, a judge should allow defense counsel to try his or her case. But let's assume the trial judge finds it to be a manifestly unreasonable course of action. Is it your view that the judge is obligated still to adhere to it, or can the judge say, I know that you don't think that we should provide that defense, but I think it's manifestly unreasonable for you to take that course, and I'm going to give that defense to this jury?
It's an interesting question. The specific claim here is not one of judicial error, but the question of whether a judge should intervene when he recognizes a defense as being manifestly unreasonable is, we'd prefer it if they did. It wasn't the case here that this was manifestly unreasonable, so the lack of intervention was perfectly proper. The judge did right by the defendant by permitting his counsel, who was thoughtful and laboring under a correct understanding of the law, to try his case as he saw fit. If I could comment briefly on one of Justice Cordy's questions from earlier, would it have been ineffective in the defendant's position, or from the defendant's perspective, to not have argued this? Or is his position merely that it should have been given as an alternative? You could see how, by steps, the defendant seeks to, have the defense micromanaged when inherent in our system is that tactical decisions are binding on the defendant. His other attempt, his other to wedge himself into Aceveto's shoes is to analogize the jury note here to the jury note in Acevedo, and that simply fails. In Acevedo is, again, a very particular circumstance where the jury telegraphed through their note their rejection of the defense, of self-defense, And they expressly asked, is there another way this can become manslaughter? Essentially, their words were, other than excessive force and self-defense, are there any other mitigating circumstances that can negate malice? This was a very rare window into juror deliberations that we certainly didn't have here. We simply had a jury asking for re-instruction on concepts that they had already heard. So, in summary, I would suggest that counsel was perfectly reasonable in this case, and the claim is simply an effort to characterize as unreasonable a defense that was merely unsuccessful. If there are no further questions.
Thank you, counsel.
Thank you.